our belief as women's rights organizations that this country should advance monogamy as the standard of marriage in order to advance equality in marriages. But these particular provisions on polygamy are taking us a step backward. The other thing that we wanted to touch upon that we actually don't agree with is the criminalization of cohabitation. As we have seen in the context of marriage, almost 27% of all couples are cohabiting. They are not living in legally recognized unions. We cannot shut our eyes to this context in our country. Cohabiting is a social issue. It's not a legal issue, and it's not an issue that is going to be resolved by punitive measures. This is something that needs to be resolved socially. We also note that many couples fail to get married, largely because of lack of funds. Marriage is very expensive. To hold a decent wedding in this country, you need at least 10 million shillings and above, just in order to gather your family. We also cannot neglect the fact that many families require bride price, which means you need to take cows. So if people can't afford to get married, why are we punishing them? By taking them to jail. This particular provision in our eyes is something that is blind to the context of Uganda and also the socio-economic realities of the people. And we fear that we may end up with almost half the population in jail if this provision is to be passed as is. The last one is around sharing of debt, which doesn't recognize the power dynamics within families. That is actually in clause 51 and 55, where they say that you can share debt if it is accumulated on matrimonial property. This particular provision assumes that spouses disclose to each other their financial liabilities, and also that women often understand the documents that their husbands sign on or present to them to sign on, especially when the women are mostly not the providers in the family. They go with what their husbands say. So this particular provision becomes blind to the power dynamics that lie within the families, where the man is the head and the woman is always perceived as the neck. What your husband says, you're supposed to do. If he says sign here, you sign here. But sometimes many women will not realize that they are accruing liabilities towards themselves. And we fear that this may turn into financial abuse ultimately if it doesn't consider the power dynamics that are within families. So these are the general recommendations that we make, and the general recommendations are on page 22 before we go to the specific ones, clause per clause. The first one is to consider removing the polygamous clause from civil marriage provisions. We know that historically in this country, customary marriages have been considered polygamous, and also Mohammedan marriages have been considered polygamous. This is something that we may not change today, but what we can change is to make sure that those that have been historically monogamous remain as monogamous, even as we push towards monogamous marriages. Additionally, we would like for this bill to provide for circumstances under which a person can take on a second wife, and these were proposed under the Domestic Relations Bill. And some of them include that a polygamous marriage should only be permitted where there is consent from the previous wives, proof of one's ability to cater for more than one spouse, and also the provision of separate residences for each wife. This is what we are calling for. Furthermore, we want this honorable committee to actually cross-check the definition of polygamy and align it to ensure that if men are allowed to marry more than one spouse, even women are equally allowed the same rights. We also call upon this honorable committee to make premarital counseling optional rather than as a requisite, because some people don't subscribe to particular cultures, they don't subscribe to particular religions. So it shouldn't be mandated that everyone should do premarital counseling. We also require this committee to do away with the provision requiring parental consent, as this violates Article 31(3) of the Constitution, and also consider doing away with provisions on sharing of debts. Specifically from page 24, you can see some of our specific recommendations and how we would like the bill to actually look like. I'll just skim through this because we have already justified what we wanted in the first place. The first one is around clause 2, which talks about the irretrievable breakdown of marriage. We wanted a more expanded definition, which we have proposed. We also want to adopt a proper definition for polygamy. Instead of saying a marriage in which a man is married to more than one wife, it's where an individual is married to more than one spouse. Clause 4.1, which is on page 25, we request this honorable committee to make civil marriages monogamous. Currently, only Christian marriages are guaranteed as monogamous unions under this bill, which in our opinion is a travesty, and it's something that needs to be immediately remedied. Polygamy should not be the standard in Uganda. On page 26, we propose changes to clause 5B, where we propose to eliminate the consent of parents, as this violates Article 31(3) as already stated. In the alternative, we propose that instead of using the word shall, Christian marriage shall be with the consent of the parents. We instead use the word may, so that some of these institutions that are carrying out the marriages have the option not to procure the marriages, especially where they feel that the consent of the parents is being arbitrarily denied. Under clause 15 on page 27, we propose to delete the requirement for premarital counseling. In the alternative, we propose that it be made optional by changing the use of the word shall to the use may, so that again it remains optional. On clause 39 on page 28, we are proposing the deletion of which allows for the conversion of a polygamous marriage, rather of a monogamous marriage into a polygamous marriage. We have made a case for not allowing polygamy to become the standard of marriage in Uganda, and this means that we cannot allow for the conversion of a monogamous marriage into a polygamous marriage. We are also proposing that if this be left in terms of converting marriages, we adopt the provisions that are under the Marriage Act 2014 of the Republic of Kenya, which allow for the conversion of a polygamous marriage into a monogamous marriage, but reject it for a monogamous marriage into a polygamous marriage. It is all stated there. And on page 29, we propose changes to clause 40, where they talk about voiding a marriage on the grounds of health conditions. Health conditions should not be the prerequisite to void a marriage. There is a difference between voidable marriages and void marriages. Void marriages are those that from the start are illegal. They are completely illegal. You cannot enforce them in any way. But a voidable marriage means that a party can opt out on a particular ground. So for us, we are saying that the inability to have sex shouldn't be the grounds to void a marriage. It should be made voidable, because sometimes people don't have sex. Under clause 43(2), we are proposing, this is on the use of names. This right is only given to women, and we feel, as Honorable Chairperson, you stated, that men are very vulnerable in this society, so they need equal rights under this particular law. If a man wants to use his wife's name, they should be allowed to use the wife's name. But unfortunately, under this bill, they are not allowed to use their wife's name, which is a travesty in our opinion. We propose that Clause 43 be amended to allow men to also use their wife's name in case they want to, in order to align with the spirit of Article 31, which allows for equal rights within marriage and upon its dissolution. We are also proposing changes to Clause 51, where we are asking for the elimination of debt sharing on property that becomes matrimonial property. We had already explained our reasons and how marriage is construed in the country and the power dynamics that lie, especially eliminated. We are also proposing a change to Clause 8, individual they are actually not married to. And it's our belief that this has no bearing on our context. These are not really cases that we have seen or cases that have been criminalized. It's just a colonial concept. And also with the registration of marriages and the opening of the marriage register, it becomes very easy to verify who is married to who. So this offense therefore becomes useless on our law books. And also we are proposing the deletion of Clause 89, which criminalizes cohabitation using other languages for reasons that I have already explained. Honorable members of the committee, this is our analysis. Our biggest prayer is that what we are looking for as women of Uganda is a law that is not going to oppress women in marriages. Thank you.
Thank you, Immaculate, for your for your able consensus by all the people represented here. You had your hand up? Please.
It was developed with everybody here, but I think it would also be great if we got just a few minutes for any other members that might have proposals, recommendations, perhaps before we can hear from the members of parliament on thoughts about our recommendations.
Okay, let's have 2, 3 so that we pick ideas. You don't need to emphasize what has already been presented. Would welcome something new from what we already have. Any?
Domestic Violence Act Coalition that is here in your presence today. I just wanted to add 2 points. One is on Clause 83 that touches a lot of the work that we do at FIDA, that is custody, maintenance, children's rights. It speaks about maintenance to cease on remarriage of the woman, which makes a lot of sense, and I must share that these are things that we see every day, that usually when a couple separates and the woman remarries, usually it becomes, the relationship, the mediations become volatile. It's usually very difficult to reach a consensus. This particular clause mentions that maintenance of the spouse, who is the woman, the responsibility of raising children still continues to be for both parents, whether they are together or not. So we've had cases where our mediation agreements start not to get implemented, usually, especially when the man has ceased having any relationship with the mother. So our proposal is that Clause 83 clearly states that maintenance of the child will not cease for both parents, whether each one of them remarries. That was one of the issues. Then the second one, let me just go to it. I think it's Clause 41 on voidable marriages. There is a 6-month timeline for consummation of marriage. And for us, we believe it might be unreasonable because 6 months is such a short time. For certain health issues, for example, that the clause speaks about, they may not show within 6 months, or people may not be okay. So we believe the 6 months limit is very short, because we believe when people marry, they keep saying forever. One day, we'll be together forever. For 6 months, for you to believe that that is not going to work because there's not been consummation of that particular marriage is also something that I wanted to just add on what Rose has presented. That's all, ladies and gentlemen.
Thank you, Elizabeth.
To reach. So I thank you and all the umbrella organizations. Now, Mr. Chairman, my issue is not specific to any clause. I have a generic issue, And the issue is that, do we need this law? Do we really need this law? Because in the introduction that the lady made, I'm forgetting the name, Rose. Rose, thank you for the presentation. It was well presented. In your introduction, you said, you alluded to the fact that this is more or less a women's liberation bill. This is the women are looking at this bill as an opportunity to liberate themselves, to start breathing. So other than looking at it as a women's liberation bill, as an opportunity for the women to incrementally liberate themselves, do we really require this law other than looking at it from that perspective? Because we have a problem. If that's the perspective, then we are going to have men also going to a cocoon to see how they can also either maintain the status quo or even liberate themselves, because there is a feeling that women have already made big gains in as far as their status is concerned in a marriage. So the question is, do we really need this law? In my view, I'm tending to think that we may not need it, because I don't see any problem. Is there a gap? People are marrying every day. Marriages are going on. Courts have pronounced themselves on key important matters relating to property. Those pronouncements are there, and they are guiding the country on how to share property in the event of dissolution of marriage. Children's rights have been well canvassed through the children's rights, but also court pronouncements. So, to me, I think this is a redundant law, but you may need to convince us whether we need to take a lot of time on this law, or we just recommend to Parliament that the situation is not so bad. It's not one of the issues Uganda is so much dying to have, such that we don't go into unnecessary tearing each other in the name of creating a law when we are actually creating more problems. Back to you, Rose.
Chair, you missed out on the applauses we got and how it is long overdue, and the historical perspective relating to it, all the way from 1964 coming forward. But you pose a very pertinent issue, which we seek opinion. It's not a summary of the discussion. It's an opinion that we seek your input. Yes, let's follow the order so that we have a schematic presentation.
Thank you, Chair, for giving me an opportunity. I would like to present it, but I tend to differ with my chair that do we need this law? For me, I think we need this law. I think some of the things are going on well. There are certain things we need to emphasize on, and if they were made into a law, it will help us a lot. However, there are some few things I picked out. One of them is about civil marriage. Civil marriage, I strongly agree with you that it should be monogamous. It has been monogamous, let it remain monogamous to protect our families. Secondly, about cohabiting. I think cohabiting has existed since time immemorial. So I again agree with you that in case of anything, say that women should be allowed to marry more than one man. I think that one, I don't agree with it, because first of all, we are going against culture. Secondly, we are going against nature. If you have married two men, you sleep with all of them one night, and you conceive, the child you have to go for DNA. That one I disagree. Another thing I disagree with is the man using a wife's name. I think surely according to our culture, usually a woman, you leave your home, to go and live in the man's home and in the man's clan. Now you are living in the man's clan, and because maybe you are the bread earner, now you want your husband to take on your name. I think that one is very wrong. I disagree with it. I beg to submit, Chair.
Thank you. You know, these are all matters of opinion, and at the end of the day, we shall. But like you say, let's keep it.
From the landslide district of Bududa. Thank you for a good presentation. Before I make my submission, I would like to tell the chair of legal that indeed we need this law. It is long overdue. Like my colleague has said in her introduction, he said we have spent 60 years. This bill has been shelved year in, term out. Term in, it is shelved because of the things that we are demanding as women that men do not agree with. But we have to live with the fact that you come in marriage with love, and at a certain moment things go bad and you have nothing to do but separate. And as you separate, how do we divide the property? I think this law has come in the right time because marriages are breaking every day. People are in court every day. And I have come in a marriage very young. I have worked for the last 20 years. You have depleted me of all the children, the beauty, everything. And you want the woman to go out empty-handed. It is not real good. But like my colleague has said, this bill has been shelved many times because of the many demands that we make and men are not agreeable with. Like he has said, there's no we can bring in and say, let the women also have many husbands like the men do. It is culture that you marry one man and that is it. It is constructed by culture. Carrying the name of a woman, it is impossible. So for us to penetrate and have this law passed, there are things we have to agree and drop as women for us to be successful. Otherwise, we are going to make these colleagues of ours mad. They will think we are coming to grab their things and whatever. I want to talk about premarital counseling. To me, I think it is very, very important. It contributes to a successful marriage. The people who go in marriage without anything, without no knowledge of what they are going to do. So they need counseling from several people. They need counseling from the parents. They need counseling from the singers. They need counseling from religious leaders. I think this is important and we need to carry it on.
Rose's argument is that we make it voluntary, not compulsory.
Not compulsory. Right. Well. Then consent of parents. Are you suggesting that we do away with the introduction ceremonies because that's part of parents consenting? Do we do away with the Kwanjula, with the Kuchala visiting, the singers, because that's part of... So the parents have to be part of this marriage. That is my submission, Mr. Chair.
Thank you, Honorable Agnes. Let's follow the order.
My question is on when you say, Rose, that premarital counseling should be deleted or should not be allowed. I think when you look at this clause 15, it is talking about even the minister through regulations prescribe premarital counseling guidelines. I think like the way we see the Catholic Church, they have even Tuesday class where you get counseling before getting marriage. I think we may not think it mandatory, but it might be an option whereby you can say marriage may, not shall. I think we can have amendment in that. And secondly, about the preandry. where women, one woman is married to 2 or several men. I think here we need experience. As my colleague she has said, that we need to benchmark and serve these women. Or these
remember
ladies who are-
information. I want to give you information that it happens, but
Yeah.
silently.
So I think as a committee, we may benchmark and see how these ladies are experiencing this. And lastly, Honorable Joab has given us a new term of contractual marriage. As a committee, which we need to think more about it and see how it can work. But really, all ladies, all men are suffering in marriage, in different marriages, which we need to give it more time and think about it. Thank you. You can also give us your submission exactly on this term.
I wouldn't want Honorable Fox to come in before you tell us a particular jurisdiction where we can benchmark on polyandry. You have one or two?
Thank you, Honorable Chair, and beg your indulgence to spend quite some bit of time on this subject. You know, I think there are matters that are settled. I call them first principles. Let me start from there. How do we want our society to be organized? This is a settled matter. It was settled way back in 1995 when the people of Uganda, through their representatives, promulgated the 1995 Constitution. And I beg to take you to only 3 articles that I will address the presentation of Rosa in respect of these matters. Number 1, Article 21 of the Constitution of the Republic of Uganda. The heading is Equality and Freedom from Discrimination. So 21(1), all persons are equal before and under the law in all spheres of political, economic, social, and cultural life and in every respect, and shall enjoy equal protection of the law. That's number 1. All persons, men, women, are equal. Number 2, Article 31(1)(a). Honorable Chair, you know this is our Bible, and this is the only instrument that binds all of us. 31(1)(a). A man and a woman are entitled to marry only if they are each of the age of 18 years and above, and are entitled at that age to found a family. No, B, to equal rights at and in marriage, during marriage, and at the dissolution of marriage. Again, underscores only one thing: equality of both sexes. The last one, 33(1) and 4. Rights of women. 1, women shall be accorded full and equal dignity of the person with men. Emphasis mine. With men. Number 4, clause 4. Women shall have the right to equal treatment with men, and that right shall include equal opportunities in political, economic, and social activities. So I would have been surprised probably before I express my surprise, I have a question, a straightforward question to Rose and your colleagues. Do your proposals fall within the four corners of the Constitution? Equality, equality. Are you asking for anything more than what was settled by the Constitution in 1995? And then I will express my surprise. I would be incredibly surprised if you came to Parliament in 2025 to ask for anything less than what is in the Constitution. To ask for anything less. And it doesn't matter whether it scares men, whether they have to. I think I usually put it this way: the men folk suffer from an exaggerated ego, which is also very thin, incredibly thin. And I would encourage you to keep poking at that ego. Keep poking every day. Don't give up. Keep poking until you attain equality. Until you attain equality. That's what the Constitution talks about. I have only one contribution, Honorable Chair. That was a preamble. I was looking at maintenance to cease on marriage. I want to propose, there's a common law principle, otherwise known as almoni pendant lite, maintenance during the course of litigation. Don't you think we should codify, and this arises from your submission, the dissolution of marriage can be a very contentious and acrimonious matter. Don't you think we should codify maintenance pendant lite? I thank you, Honorable Chair.
But Honorable Fox, thank you. Maintenance, and the ex-spouse wants to move on, has got Joab, is taking him on as a wife, and that's where the contention is.
Relating to children on the dissolution of marriage. But perhaps before we even get to orders relating to children on the dissolution of marriage, how do we manage the litigation phase? How do we manage maintenance of children and spouses during litigation?
Okay.
Yeah.
Thank you so much, Fox. You know, we
went to the university around the same time, and he used to be very broke. So he would come and bench, and I walk out and go to one day and get pork with the one who's loaded. But that's off record, please. Thank you. I'm not a member of the Legal or Gender Committee, but I'm a member of Parliament. The woman MP for Pakwach, I'm called Avur Jane Pachuto. Chair, two things. I just want to pick on, while I was putting my hand was when Honorable Neolin was presenting, and she was talking about liability, probably, and assets. And I participated during workshops of this marriage bill. And I know that nobody is born married. There's a process to get to be married. And some marry well at 18, these days even 14. Some marry at 57, 40. Some marry at 35. So because of that age difference, no fixed age where one can get married, most likely one of the spouse or partner will go into marriage when he or she already has assets and probably liabilities. Now, when we talk, when I do not transfer my assets to the marriage, it is not part of the marriage. That's what I understand. If you got me when I already have a car, I have a house or land, and I did not transfer that, we live all our life and I don't transfer, I don't think the other spouse can claim it in any way. Same with liability. If you have a loan in the bank and we have not discussed it, you have not even disclosed it, and you've not transferred it to the marriage, then how is it? How are we arguing that, you see, I've come in this marriage, I had my big loan of 200 million, so you must take over. I think we need to be careful there, because I may have got that loan and I've not disclosed it and I want it that way. So for me, Honorable Neolin, that's where we don't agree. And then I want to agree with my brother that came before Honorable Neolin. People, I think we need to know the society from which we are coming from. From the time I was born a girl, I was raised a girl, not a man. I was even taught how to sit, how to talk, but of course talking I became a little bit different. But I was taught certain things. Even up to secondary school, I happened to go to a Catholic school. We were taught not, mangoes were in the compound and you are not supposed to run as a woman. When it drops, because you're in a community, walk and pick, or wait for them to be picked and brought to the dining. No struggling for food. So, I think our bringing in African society, especially the culture where I come from northern Uganda, marriage is not for economics. It is social. No woman in Pakwach there, I'll tell her, when you get married, first get to know how many bicycles, how many vehicles, how many plots of land, and they will take me seriously. They have come to marry, till the land, do maybe some business, produce children. And they are shown the land. This is where you are going to start digging. My brothers still dig and build where my grandmother, who was married in that clan, dug. So, whereas we must cope with the modern times, we must integrate our traditional, the positive aspects of our traditional, whatever. We cannot afford to start telling young girls in this society that as you go, Honorable Fox, he has a whole beach for himself. He has an airport. Then we are going to make the institution of marriage just a target. We are going to have target, marriages. I come, we sign the certificate, and because I must claim that property, people even are going to kill each other, because when Fox dies, after all, I'm the married wife, I'll take over everything. I think marriage in our society, in the Ugandan society, most societies, is not for economics. It is social. And let us encourage women to be also hardworking. Women to own property. There is no law that forces you, because you are married, you must bring everything in the marriage.
Thank you, Jen.
Thank you. Then on sexual harassment.
I want you to be...
I want to go away, Chair.
No. We have not yet received that presentation.
When are you receiving?
After this.
Okay, Chair, thank
you. Finally, but we need to run because we have an...
As women. So we cannot give an opinion that is for men. I know that men are used to women looking after them, and you expected us to come here and look after you. But we are not. We are going to be selfish today and request this committee that also has men to look after us as the women by guaranteeing us equality in marriages. So that is why our opinion is biased, because we are women. We are not men. Do we need this law? Yes. And I'll speak from my experience as a divorce lawyer of over 10 years. They can change sides. Do we need this law? Yes. And I speak from my experience as a divorce lawyer. People have been saying, I've been married for 25 years, what? I have 10 years experience running around in family division. What happens when it comes to a marriage ending? There are two issues that are most contentious. One is children, the second is property. We may not want marriage to be economics, but unfortunately it is. It is the basic unit of society. It is the basic unit of production.
Sorry to interject. Does any of the people represented here have any statistics of divorce for the last maybe 1, 2, 3, 4, 5 years?
We can avail. We can avail.
Yeah, I would love it.
We can avail. So it is the basic unit of production. You cannot divorce marriage from economics. You would be telling yourself lies. All this of we are going in for emotions, what. When it's time for him to divorce you, you begin to wonder, where is my food going to come from? Where am I going to live? How am I going to survive? And unfortunately, our current laws do not address the economics of marriage, which has created backlog in family division because parties cannot decide or consent towards property. And when you talk about the cases where you're saying they have decided, unfortunately, it is high court judges who have decided most of these matrimonial property cases. The problem with that is that another high court judge can depart from that opinion. Constitutional Court hasn't pronounced itself on the issue, neither has the Supreme Court. So we still have challenges distributing matrimonial property. So it is the Parliament's duty to settle the issue of matrimonial property because we have a huge challenge. The issue of children was settled, but the one of matrimonial property, we still have challenges. Polygamy. Our challenge with this law is that it is creating a standard of polygamy in marriages in Uganda. And yet our statistics show that most people are monogamous. So why are you making polygamy the standard? That is the question that we ask. And then it comes down to the issue where you're talking about women want to marry more than one husband. We are talking about equality in law. The purpose of the law is supposed to create a standard, and the standard must be equal for both men and women. Our current laws under the Customary Marriage Registration Act are open. Actually, women can marry more than one husband under our current law. But does it happen? Actually, no. Why are you presuming that because you create one unique standard, suddenly all of us are going to go and marry more than one husband? What we are asking for is equality. Whether it actually happens, who knows? A few years ago, I wouldn't wear trousers and appear before you, but here I am. A few years ago, I wouldn't be guaranteed an education as a girl, but here I am. Society changes. It is not static. So maybe 10 years from now, I'll be allowed by society to marry more than one husband, and the law should accommodate that. The other issue I wanted to raise is around names. Honorable, what I want to tell you is that we do not draw identity from names in Uganda. We draw identity from our clans. At least in Bugisu, that is what happened.
Excuse me, Chair, allow me to give some additional clarification.
No.